Execution secretary ತಾನೇ ಮಾಡಿದ್ದು, ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಸೆಕ್ರೆಟರಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ, ಇದರ ಆರ್ಡರ್ ಅಲ್ಲೇ ಇದೆ ಸರ್.
ಹೇಳ್ರಿಪ್ಪ, ಮಿನಿಸ್ಟರ್ ಎಲ್ಲರಿಗೂ ಅವನೇ ಮಾಡಿದ ಆರ್ಡರ್. ಮತ್ತೆ is not correct picture is not, you don't know.
Let affidavit be filed
Please.
on Monday.
Please.
Within how much time this order under
Yes.
131 will be complied?
We'll file it.
Learned senior counsel appearing for the petition.
One submission.
Yes.
I may be pardoned.
Yes.
Page 5 ಅಲ್ಲಿ my lord, ನಮ್ದು ಇದು ಹಾಕಿದ್ರಲ್ಲಿ your lordship can get the clue. Earlier I had approached the honorable court directly. This honorable court in writ petition number 20, last 3 lines my lord, first paragraph. Page 5 my lord.
Yes.
Last 3 lines.
201961.
201961 of 2017 ದಾಖಲಿಸಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 30/5/2018 ತೀರ್ಪು ನೀಡುತ್ತಾ ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಅಧಿನಿಯಮ 1983 ಕಲಂ 131 ರಲ್ಲಿ ಸಲ್ಲಿಸುವ ರಿಟ್ ಪೆಟಿಷನ್ ಅರ್ಜಿಯನ್ನು 2 ತಿಂಗಳ ಒಳಗಾಗಿ ಇತ್ಯರ್ಥಪಡಿಸುವ ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತದೆ. The submission of my friend that it is contrary. No, merely by saying that we have complied, we have considered.
Now he has changed his stand. Just wait.
Yeah. That is how what I am trying to pursue your lordship is, that is how they are dodging and just under the nose of this honorable court they are floating the orders of the court.
Just 1 minute. The learned counsel for the complaint, senior counsel appearing for the complainant has filed a memo and enclosed order passed under section 131 of the Education Act, passing directions to the effect that the post to which Ravindra was working and proposal was sent has to be admitted to grant in aid.
How sir? Even otherwise also my lord, only one post now.
Just 1 minute. Necessary affidavit to be filed by the concerned officer of the education department as to the status of implementation of the order passed under 131 relist on Thursday.
Monday bad.
Thursday.
My apprehension is my lord, if there is change of roster again my friend will be taking.
We are aware of it. Malikarjun, you just instruct.
Definitely.
No, sometimes
Affidavit must be filed by Thursday.
with pain I am forced to make
No,
some submissions my
We
lord.
are with you on that.
Obliged.
We are with you. Yes.
Number 12, Arun Kumar Amarabundappa.
In this matter, my lord, your lordship has directed me to get the survey, my lord, and submit the report. Madam. My lord, last occasion, my lord, without owners, my lord, we made the inspection and made the survey. Then your lordship directed to, after issuing notice to the owners, you made the survey. We made the survey, my lord, in the presence of the owners only. Now, my lord, now the sketch is filed by the, my lord, ADLR, my lord. This 2 portion only, my lord, submerged. That is in the which is color marks, my lord, that portion only submerged in the.
Yav submerge ಆಗಿರೋದು.
That portion, my lord,
69 bar
60, my lord, 62/9, my lord, to the extent of 30 gunta, my lord, it is.
ಆಯ್ತು.
Then, my lord, survey number 64/23, my lord, 2 acres 30 gunta is submerged.
2 acres
30 gunta.
Okay.
Now, my lord, the proposal is also given by the, my lord, concerned department to the land acquisition officer, my lord. So now, my lord, we'll proceed with the acquisition.
What is that extent? 66 LA?
Total, my lord, that is,
66 LA.
yes, my lord. In the memo, my lord, I stated, my lord.
Yeah.
And page number 6, it is very clear, my lord.
Page
Number
number?
6, page number 6 of the, now I find the memo, my lord. Total area under request. This is the request, my lord.
It is.
Survey number to be acquired. 62/9 and 64/23.
That is over.
Yes, my lord.
Now, you say even in 66,
Please.
some extent is to be acquired, isn't
Yes,
it?
but that is not, my lord, mentioned in the present, my lord, report of the ADLR.
Well, you ask them, they may have said.
Yes, my lord, that is, my lord, that is the variation, my lord. That's why, my lord, I asked the ADLR to file the detailed report. Earlier, my lord, 14 guntas, my lord, they shown. Now, my lord, they not, my lord, shown, my lord, submerged. Only these two survey numbers is, my lord, shown. This is the proposal we already sent to the concerned department.
Now the who's present now?
Now, my lord, surveyor, irrigation department and land acquisition officer.
Correct. This sketch is prepared by whom?
By the ADLR, my lord. He is not present, my lord.
Ah,
That's why I asked him to
ah.
send the report, my lord, at 2:30, my lord, I'll file it.
Pass. Now that pink portion,
I will ask
portion, purple portion in 66.
Yes, my lord.
They have to say how
Now,
much.
my lord, is a change. That's all.
Pass over.
The 30 came करके
Yes, next.
It's to appear for complainant.
Your Lordship, I am
You
filing
have
the
filed
report
some
of
memo, my lord. I will file rejoinder statement. There is no compliance of the direction issued by the learned single judge. While now passing the order, my lord, all new set of documents have been brought. And the documents which were filed along with the writ petition, they were been given go by, my lord. Now, what kind of order he has passed, my lord? We are unable to understand. All the old documents which were there, part of the record proceedings, and the respondents 3 and 4 who have made illegal construction.
Correct. But now that order you'll have to challenge. How we can decide?
No, but here, my lord, what happens here, when the documents are produced along with the writ petition, at least those documents could have been effort while passing the order, my lord. All those documents are being given go by. Now some new notice has been issued and says that he passes some order. What kind of order he passes, that is also unable to.
Now under which provision order must be passed of the?
Under the Karnataka Municipalities Act, section 187.
Koti.
Yes.
My lord, my respectful submission.
Just 1 minute.
Please.
Whether any order is passed under 187 or no?
No, my lord.
No, my lord. They are seeking only simple mandamus, my lord. By considering the direction of this honorable court in writ petition, my lord, the respondent officials are visited the spot and conducted the spot panchnama in presence of petitioner and respondent, my lord. The house were constructed, their allegation, complainant allegation is that, my lord, the house were newly without construction permission, they are constructed the house. But house is constructed in the year 19.
Just Mr. Gate, you right or wrong, some orders passed, you have to challenge it in accordance with law.
No, my humble submission.
It may be wrong, it's a wrong order.
My humble submission, at least para number 7 of the writ petition, which I have specifically mentioned.
That you challenge.
Under
that
what
order.
provision of law he requires to pass the order.
That you challenge that order. We can't go beyond it, behind it in these proceedings.
My liberty may be reserved.
Yes. The learned single judge had disposed of the writ petition directing the Chief Officer Town Municipal Council Balki to consider representations given by the complainant at annexure F, F1 and F2 within a period of 3 months and to pass appropriate orders. The council appearing for the local authority has filed a memo along with the joint inspection report and an order.
And regarding there is a delay, there should be some explanation, some affidavit. Adano file madilla. Just throw a memo. Compliance of the contempt proceedings order passed by the learned Singh judge, how much time they have consumed, how much time the parties are to appear before the court, my lord. That was all not the courtesy of the officers, my lord. Just they put a memo and get it close.
And notice dated 10/2/2025. 10/2/2025. Full stop. Though counsel for the complainant submits that the manner of consideration is without application of mind and is contrary to the facts on record, that is an aspect left open for appropriate challenge. Full stop. However, we are in consonance. Direction. April 24. Petition is filed in October 24. Now, why no affidavit is filed?
My lord, due to my absence, my lord,
No,
today I'm
not
unable
your.
to.
Not your.
At least there should be a courtesy, my
So,
lord.
I'll.
Cost of 5,000 for this nonchalant attitude.
So, sorry, my lord. Tomorrow itself
No,
I'll
no.
file an affidavit.
No,
my
no.
lord.
Next. With the contention of the petitioner that the contempt proceedings ought to be treated with utmost seriousness and diligence, as court is seeking to uphold the majesty of the orders passed by this court. Compliance, even if done, cannot be presented, especially when there is a delay. Especially when there is a delay. By mere filing of a memo without explaining delay in consideration. Full stop. Notice the order of the single judge who had directed consideration of the period of 3 months from 23rd April 25. Memo is filed on 17/2/2025. The much delay in light of absence of any explanation regarding delay, though proceedings are dropped, the respondent number 2 to pay costs of rupees 2,500 personally to the High Court Legal Services Committee.
Great.
Yes, all contentions are kept to.
40, DG Chakashetty.
Lord,
I am
in this
appealing for the
matter,
complaint, man. For Arshit, kindly
in this matter, my
kindly
lord,
peruse the
within 1 week, my lord, we
Page
will pay
number
that
18, my
arrears of the, my lord, there is a direction to pay the, my lord, arrears salary, my lord, during that relevant period, my lord. We already, my lord, sent the proposal, my lord, within 1 week, my lord, lords pay it Monday, my lord. By that time, my lord, we will pay that amount.
Relist GA submits upon instructions that order would be complied with. Relist for report of compliance on 24th.
Please.
Finally,
Please,
no further. It's made clear that there no further time will be given.
please.
Kartik Ranachari.
this is
I appear for the appellant in this case, sir.
On the order of the magistrate only, they are
I beg-
directly filed appeal before the honorable.
Acquittal,
Oh,
acquittal judgment
yes, ma'am.
by the magistrate.
Yes, ma'am. This could have been filed before the district and session judge.
Yes, madam. Yes, madam. You have to approach the session court. 372, where the appeal ordinary lies.
I'll
Read section.
withdraw.
Yes, yes. Then you file a memo. Then counsel for the appellant files a memo seeking permission to withdraw this
Please.
appeal with the liberty to file the same before the sessions court.
Yes.
Preserving such liberty, appeal dismissed as with certified copy of the original to be returned to the counsel for the appellate
Please.
by substituting the photocopies.
Yes.
Number 60, Ravi B. Patil.
Blessed. Kindly 2 days time may be granted for furnishing of correct address of the respondent lordship. Earlier notice was sent.
Week's time granted to furnish correct address. Yes.
Please.
Number 17, D.P. Ambedkar.
My lord, this honorable court has directed government to verify court fee. That's
Relist. AG is directed to take necessary stand. Relist the matter. First week of March date.
much.
6-3. Number 80, Arun Kumar.
Your lordship,
In
the
this
order
matter,
has
my
been,
lord,
the order has been complied, your lordship.
Learned counsel for the complainant submits that the order, contempt of which had been complained of, has been complied. In light of the said submission, proceedings are dropped. File a memo. Memo.
Yes.
I'll take notice for R2, my lord. Is served, my lord.
GA accepts notice for R2.
R2. Obliged.
Yes.
Number 90, Mahadev S. Patil.
Appearing for the respondent 1.
19.
This matter,
Senior is
Lord,
appearing on which email?
notice to respondent number.
Last occasion, your lordship directed the ARCS, I think, to serve the copies on the respondent 5 to 8, I think, for the societies.
Yes.
Serve ಮಾಡ್ರಂತೆ.
Who's the counsel?
Government, my lord, government has.
Government.
Your lordship has directed to serve through GM. That is through respondent number 3.
4.
4 ಅಲ್ಲ 3 ಹೇಳಿ. Last date of order, my lord, your lordship can.
On 6/2.
6/2.
There was a direction to respondent number 3, who is represented by government advocate, to steps to, my lord, see that respondent number 5, 6, 7, 5 to 7 should served through GM.
But in fact, my colleague, Mr. Mahadev Patil, has submitted a complaint memo. My lord, he has served it in personally and filed the report. In spite of it, your lordship directed the deputy registrar of cooperative societies to serve them.
And summons, my lord, what is given to us or not, my lord? What is that?
Next.
And in fact, they remain. I'm sorry, my lord, to interrupt. They remained absent before the learned single judge. But the question is now, the 10th respondent has to go back to the director of post of the DCC bank, though he was holding 4 posts, 4 membership and 4 presidentship in the 4 cooperative societies, and he resigned 2 and remaining 2, and again he want to become one more society's member. That order of the learned single judge quashed both the orders of Annexure D and H of the authorities. Let there be an interim order, my lord. Let him. He's already approached the DCC bank now, and is nothing but abuse of law.
Who appears for the 10th respondent?
10th respondent, my lord, I am appearing, my lord. It may be posted for admission, my lord. We have also engaged senior counsel. And in fact, my lord, before the learned single judge, 5 to 8 service was completed. They are unrepresented. Held sufficient.
Here also, my lord, we serve the, my lord, hand
Let them, my lord, the notice may be completed. Any date may be fixed, my lord, for final.
Let my learned friend take responsibility, my lord, not to precipitate before the DCC bank. And that may be other undertaking may be recorded.
It may be taken up tomorrow, my lord. Yeah, the order sig bandide ante I cannot inform the, my lord, senior counsel.
List the matter on. We'll have it on 24th. You come ready.
Yes.
List the matter On 24th, you come ready, please.
I request a
For
final hearing, if
consideration-
your lordship has to hear on the final hearing.
For consideration of interim prayer.
Interim prayer, great.
For consideration of interim prayer.
Great.
In the interregnum, earlier direction regarding service of notice to respondents 5 to
8.
5 to 7.
5 to 7.
7.
5 to 7 through the
5 to 8, my
5 to 8.
5 to 8 actually.
respondent number 3
House of.
to be complied with.
Please, madam.
The my lord, and summons has to be handed over,
Office to hand over hand summons forthwith.
please.
Please.
20, Dastagir Sahib.
Seeking or time for seeking file necessary applications you are also. Filing necessary applications, rejoinder application.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕ್ತಿದ್ದೀನಿ sir. Short time ಕೊಡಿ.
ಹಾಕ್ಬೇಕು.
Yes.
Weeks time granted. Application for what?
Rejoinder application with along ರೋಡಿ ಅಕ್ವೈರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿ ಏನು ಇಲ್ಲ.
Not yet ordered. my lord. Why? Notice is not yet ordered.
ಇನ್ನ ನೋಟಿಸ್ ಹಾಕಿಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾವು ಕೊಟ್ಟು.
ಅಲ್ಲ ನಮ್ಮ ಲೆಟರ್ ಮೇಲೆ ಕೊಟ್ಟಿರ್ತೀವಿ ನಾವು. Most other
No,
question.
correct.
Notice has to
You
go
have
to
taken the stands complied. So interim file is rejoined.
the petition copy, my lord, is not served, my lord.
ಒಂದು extra,
ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ಕೊಟ್ಟಿದ್ದ ಕಾಪಿನೇ ಅದ ಸರ್ ನಮ್ಮಲ್ಲಿ.
ಆಯ್ತು ಒಂದು extra
ಒಂದ್
copy,
ಕೊಡಿ, ಇನ್ನೊಂದ್ ಕೊಡಿ copy.
ಒಂದು extra copy.
ಹಾ.
Rejoinder if any within a week's time. Relist the matter.
24. 24.
Yes.
21, Ravi B. Patil.
ಹೇಳಿ ಹೇಳಿ ಸುಮ್ಮನೆ ಹೇಳಿ.
Yes, Mr. Nadav. ನಿಮ್ಮ ಕೇಸ್ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಅಲ್ಲ, ನಿಮ್ಮ ಕೇಸನ್ನು ರಿಪೋರ್ಟ್ ಮಾಡಿ. ಸೆಕ್ಷನ್ 6 ಮೇಲೆ ರಿಪೋರ್ಟ್ ಮಾಡಿದೆ. ಇಟ್ಸ್ ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್. ಫಸ್ಟ್ ಟೈಮ್ ಆಗ್ತಾ ಇದೆಯಾ ರಿಪೋರ್ಟ್? ಗುಡ್.
Yes, next.
My lord, in this matter, my lord, page number 16, may I request? my lord? Page number 16, may I request? my lord?
Yes.
My lord, one Tulsi Ram and Dondiba filed a writ petition through their power of attorney. Lordships get it. House title in my lord, page number 16. One Tulsi Ram and my lord Dondiba files my lord a writ petition through their power of attorney Ramesh Gaikwad as against state and my lord one Tajuddin. Respondent number 5 is a Tajuddin. The appellant herein are the wife and children of my lord deceased Tajuddin. May I take my lord this notice to R5 is held sufficient. He had shifted my lord to Hyderabad in the year 2011 after selling the property in favor of
Tajuddin.
how? After selling the property in favor of appellant number 5 and 6, he had shifted to Hyderabad and they have taken a paper publication showing this
Just
address.
1 minute, just. Now, appellant 5 and 6 are the applicants seeking leave.
Yeah.
Huh?
Along with my lord, the LRs of Tajuddin, because they are also my lord, filing the appeal challenging this order.
Along with
LRs of my lord, Tajuddin.
Tajuddin is dead.
Tajuddin is dead.
When did he die?
My lord, 19/12/2024, after disposal of this writ petition.
1912.
2024.
Writ was disposed of on
19/12/2020. Writ petition disposed of on my lord, 21st October 2024.
Tajuddin died.
House.
Now you are saying that the notice on Tajuddin was not correct.
House.
That is your contention.
Along with that, my lord, there are other grounds also, my lord. To show that, my lord, he was dead, my lord, there is a entry in the, my lord, graveyard, but still, my lord, we need to secure, my lord, the death certificate.
Tajuddin is dead.
House.
So we'll
House.
allow him to rest in peace.
Yes, yes, please.
So now one of your contention is that the notice on him was not complete.
Not completed.
Huh?
House.
he was not represented through any counsel in the
No,
single judge.
no.
Okay, on 15/7, notice to R5 held sufficient.
Out.
Now that you are disputing that it
Yes,
was not.
yes, yes, yes.
On what ground?
My lord, on merits also may I request, my lord?
Merits will go later.
Agos. My lord, the application, my lord, filed by, my lord, the petitioners, my lord, which is also produced, my lord, after, my lord, the copy of the writ petition. Page number 127. I'm sorry, 121. 121.
Page
121.
121.
ಅವ್ರ ಪ್ರಜಾವಾಣಿಯಲ್ಲಿ ನ್ಯೂಸ್ ಪೇಪರ್ ನಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ತಗೋತಾರೆ ಶೋಯಿಂಗ್ ದ ಅಡ್ರೆಸ್ ಆಫ್ ಬಿರಿ ಕೆ ವಿಲೇಜ್ ಅಂತ
121 is a statement of objection.
ಅದಕ್ಕಿಂತ ಜಸ್ಟ್ one page before. Application filed in the writ proceedings.
Substituted service.
How?
Yes.
ಇದನ್ನ ಪ್ರಜಾವಾಣಿಯಲ್ಲಿ ತಗೋತಾರೆ.
Correct.
This address of deceased was shown as Biri K.
Tajuddin was shown as
Biri K village.
Beer K. Beer K.
How?
Beer K village, Balki.
Balki.
Bidar Taluk.
How?
Bidar district, Balki Taluk.
How?
Tajuddin was staying where according to you?
Hyderabad.
He was not staying in Beer.
How? And he had sold out the property in favor of appellant number 5 and 6 way back in the year 2011 itself.
2011. Registered sale deed.
How? Registered sale.
Date?
I have produced, my lord, the copies also. The date of sale deed is, my lord, 9/5/2011.
9/5/2011. Sale deed by?
By, my lord, Tajuddin.
In favor of?
Appellant number 5 and 6. Joint sale deed. I have produced the copy of, my lord, the sale deed along with the application seeking production of additional documents.
Now this appellant 5 and 6 were not parties in the.
No.
Not parties.
No.
You are the purchaser.
How?
Where's the sale deed?
Along with the application for seeking production of additional documents. I number 4.
Page number?
IA for production, IA number 3 of 25.
Page?
First page after, my lord, the application, my lord, page number 130, 149.
Tajuddin in favor of Ganga Shetty and Basappa.
How?
Now you
Now
are.
Basappa is also no more, wife is representing. Basappa is also no more. Wife name is already entered in the revenue records.
Already entered.
How though? 2011 in the name.
Just one minute, just one minute. Now in the writ appeal, Basappa's children, wife is appellant number?
Appellant number 6 here.
Puttalabai.
Puttalabai.
That is Basappa's LR.
How?
Now who's the other?
Gang Shetty is, my lord, the co-purchaser.
Ganga
Appellant
Shetty
number 5. How?
Now the challenge before the single judge was as regards what?
My lord, the
revenue entry.
How? The issue raised by, my lord, the petitioner that they were the owners of land in survey number 103. My lord, which was acquired in the year 1979. 1979.
Survey number?
103.
Now the subject matter of the sale deed was 103.
103.
103.
How? What happened, my lord? 10.
Just one minute. Now, what was challenged before the single judge was the order of the deputy commissioner or?
Assistant commissioner, order of assistant commissioner was challenged before deputy commissioner, and in turn, my lord, they have challenged before
DC's
this
order. DC's order also.
AC order challenge madidare. Then DC order, both, my lord, the orders are challenged.
Now in those proceedings,
we are not parties.
No, in those proceedings, what was challenged was the entry in 103.
Mutation entry in favor of Tajuddin.
Tajuddin.
How?
And that was subsequently changed in favor of the appellant 5 and 6.
How?
Huh?
How?
Now the Sale deed is 2011.
Howd.
But entry was 1st May, which was challenged in favor of Tajuddin,
Yes.
was prior to the execution of the sale deed.
Howd.
And then
That mutation.
technically, it's like something like list pendants. No?
That was disposed of in the year 2011.
Correct.
Appeal was preferred, my lord, in the year 2000. Revision before deputy commissioner is of the year 2014.
No, correct. What we are saying.
And we are not a party.
No, correct. What we are saying, as on the date of challenge to the revenue entry, sale deed was not executed. What was challenged was the MR in the name of Tajuddin.
How?
That was in the year which
2014.
2014? No.
Mutation is dated 28/3/2011.
Correct.
ಅದು ಆದ್ಮೇಲೆ 2014 ನಲ್ಲಿ ರಿವಿಷನ್ ಹಾಕ್ತಾರೆ.
No, just 1 minute. 28/3/2011 is the mutation.
How?
In favor of Tajuddin.
Yes.
Now that was challenged.
Before deputy commissioner.
AC 136(2). First AC.
ಇಲ್ಲ, order itself is by assistant commissioner.
Correct.
Order itself is by assistant commissioner.
MR is by whom? Tahsildar.
It was before the assistant commissioner because the Tahsildar has got power to make entries only if it is within 3 years. Here is a case which has been acquired by the government, and then in lieu of exchange, the property is given to.
Now the MR was affected by whom?
Pursuant to the order of assistant commissioner only.
Assistant commissioner. What is the date of the order?
28/3/2011.
Correct. So as on that date, sale deed was not yet
No.
executed.
No.
So then
Revision was filed in the year 2014, after 3 years.
Right. So as on that day, they made whoever parties.
2014 ನಲ್ಲಿ we were parties. Once 28/3/2011 was passed, then in the month of May, the alienation was made in our favor, at which point of time there was no revision.
Correct, Mr. Patil. Now, when the AC passed an order, sale deed was not yet done in your favor.
How? Insofar as 5 and 6 are concerned.
Correct. Subsequently, it was done.
How?
So now you will have to implead yourself. You should have impleaded yourself in those proceedings.
Now the issue is looking into larger whether the lands were acquired in the year 19. May I take 2 minutes of the court to explain what
Acquired
is
by?
Acquired by the authority assistant commissioner, who is a land acquisition officer. Acquired for the
Which year?
1979.
Yes.
Compensation was paid in the year 1979 to the owner of the land, who being the father of the petitioners.
Compensation was paid.
Paid.
Now this is with respect to what extent?
Land in survey number 103, measuring 2 acres.
So now the fight, if any, is only in so far as entitlement to compensation technically.
Illa. May I take further. This land 103 acquired for the purpose of construction of houses for houseless persons under Ashraya Yojana scheme. However, this land was felt not suitable for construction of houses by the government. Then what they did, they exchanged the land with survey number 57/2, which originally belongs to the Tajuddin. 57/2 is utilized for construction of houses under Ashraya Yojana scheme, and Tajuddin was given in exchange of 57/2, measuring 1 acre 36 guntas. They have exchanged for 103.
Yes.
And now 57/2, there are houses constructed, and the entries are made in the name of state government. And in lieu of exchange, Tajuddin was put in possession in respect of 103. And he made an application before the assistant commissioner for effecting entries in his name. That was considered and allowed. Entire detailed order has been passed by the assistant commissioner. Said order was challenged before the deputy commissioner. And deputy commissioner also reappreciated that there was an exchange of land. Therefore, 103 had to go to Tajuddin, which order was a subject matter of challenge before learned single judge, contending that there was no compensation paid, or they have taken several grounds. Government has filed the statement of objection, producing all the records to show that land was acquired, award was passed, compensation was also paid. Annexure R1 and R2 were the documents which are produced before learned single judge.
That's not in dispute.
Yes. Now the records pertaining to the land in survey number 103 as on the date of filing of the writ petition, as well as as on the date of filing revision before the deputy commissioner should stand in the name of appellant number 5 and 6. Petitioner do not choose to make 5 and 6 as a necessary party. They select the Tajuddin to be made a party, and they have challenged the order. And then the learned single is passed an order remitting the matter to the assistant commissioner. However, in the operating portion of the order, the revenue entries are directed to be restored in the name of the petitioners. That is taking advantage of that. Now our names are being deleted. Name of appellant number 5 and 6 who were not the parties before the proceedings, their names are being deleted, and now the name of the petitioner are being entered without holding any inquiry, and matter is being stalled at this stage only. Now petitioners are trying to alienate this property in favor of a third party.
So what is the relief you are seeking?
Challenging the order of learned single judge,
Correct. That
insofar relates to restoring the name. Let the assistant commissioner hold inquiry whether they are paid.
So in the interregnum, what is the interim relief you are seeking?
The operation and enforcement of order of this learned single judge requires to be stayed, because now the entries what they are trying to and secure with respect to the property, they are trying to alienate the property in favor of third parties. Therefore, I have filed application.
Correct. The single judge, while remanding the matter,
yes,
has passed some observation why restoration of names is being resorted to, or
page number 22, my lord.
20?
22. Para number 7. A plain reading of the aforesaid provision will clearly indicate that an appeal would have to be filed under 136(2) of the before the assistant commissioner by an aggrieved person, and in the instant case, in the absence of any such appeal being filed either by respondent number 5 or anybody else, the third respondent assistant commissioner did not have jurisdiction or authority of law to initiate suo motu proceeding by invoking section 136(2), which is clearly impersonal in the law, and on this ground also the impugned order passed by the respondent number 2 and 3 deserves to be set aside. The appeal before the assistant commissioner is treated as a suo motu appeal, but it is at the instance of the deceased Tajuddin.
Now the order of the assistant commissioner, order of the assistant commissioner is at page?
Page number 41.
41.
That is my writ petition. 41 is my writ petition number. Writ appeal changes.
We want to have a look at the order of the
assistant commissioner, page number 41, annexure B.
Just 1 minute. Order of deputy commissioner and assistant commissioner, both you show.
Yes.
Now assistant commissioner is annexure
41, my lord.
Page 41.
How? ಅಲ್ಲಿ ನಿಮ್ಗೆ 16 ಇತ್ತು 16 ಇತ್ತು.
Cooperative portion of that?
My lord, at page number 43. And assistant commissioner writes a detailed order, my lord.
No, correct. Now by virtue of the setting aside of the AC order, entry in Tajuddin goes, so it stands restored in the government's name, correct?
But by the time this order is passed.
Correct, we'll come to that. I'll come to that. I'm just trying to understand. So by virtue of AC order, government was cancelled and Tajuddin's name was included. Now that order has been set aside, by virtue of which the original record, it stands in the government name as on date.
That is in respect of 57/2.
Correct.
There are two survey numbers.
Correct.
Operating may read PTKL
No, one nimsha. Just make me understand.
Please.
Now, Tajuddin's name was removed from 57/2.
How?
And directed to be put in 103.
How?
Isn't it?
How?
Now this order is set aside.
How?
By virtue of which technically 57/2 Tajuddin name stands restored.
Adu madilla.
Alla aaytu. That is the effect. Suppose
if this order has to go in entirety, it has to go.
Has to go.
How?
That is one.
How?
So then the transfer of Tajuddin in 103/1 technically will go, and then it has to revive in 57/2. Now what has happened to 57/2?
They have put up a construction of houses under Ashray Yojana scheme. In lieu of exchange, my land was taken, and they have utilized the land for construction of a house.
In 57/2.
How? Even if entries are made in respect of 57/2, it is of no use for
Correct. Now, in so far as 103/1,
How?
It was belonging to the government,
belonging to the father of the petitioners.
father of the petition.
That was acquired. Acquisition documents are also produced. In fact, government itself has produced the records before single judge.
So the petitioner didn't have any right because it was extinguished
Yes.
by acquisition.
Yes.
That land is given to you.
Yes.
Instead of 57/2.
Yes. What they claim is they continued in possession of the property, and for the first time 2011 only they are sought to be evicted pursuant to the order of Assistant Commissioner, and therefore they challenge the order of Assistant Commissioner and Deputy Commissioner.
Yes.
Lord, as per Annexure A in my writ petition, my land was acquired in the year 1977. I am handicapped to point out the page numbers. However, my lord may turn to page number 35. I don't know how far it is, right?
35, correct.
35, page number 35. Annexure A of my writ petition. Kindly turn to page number 36.
Yes.
From bottom, my lord will see. From bottom.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The lord, the BDO, Balki, in a capital letter it is written, Lord, payment of interest. Payment of interest, capital letters. Page number 36.
Yes.
The BDO Balki wide letter number so and so has requested that the date of taking over the land will be intimated in due course. The landowner, therefore, will be entitled for interest at the rate of so much from the date of taking over the possession accordingly. Possession of the land is not taken at all. Compensation is not paid at all. According to Lord, the government statement, they say that they have paid the compensation in the year 2010, whereas my father died in the year 1999 itself. Till now, government is not in a position to show the acknowledgement for having received the compensation. Learned single judge has put on the Assistant Commissioner to show this. Never. Finally, the learned single judge has allowed the writ petition, remanding the matter to Assistant Commissioner to go into it. I request my lord to.
No, correct. So now that will decide.
Yes.
The order of remand he has challenged, that will decide. Yes. In the interregnum, you don't create any third party right. Matter still to be decided. Now let us see. Matter after all is remanded. So you don't create any third party rights. Let us see. We'll hear the matter.
As per the order of the learned Assistant Commissioner, kindly. I have not filed appeal. I have not filed appeal. Kindly see Assistant Commissioner's order, Annexure B. Whereas my learned colleague has read it out.
So correct. What we are saying, now the matter is remanded, isn't it?
Yes.
So we are saying for the time being, he has challenged that order of remand.
Yes.
In the writ proceeding. Yes. So you don't create any third party rights till the next date. We hear the matter.
No. My lord, at the instance of contempt court orders, direction, my name has been entered, restored.
Is there? But
yes.
What we are saying now, still matter. We are not disturbing that. We are saying don't create third party rights on the basis of those entries.
True, my lord.
For the time being,
true.
We'll hear the matter.
Till now, my lord, I have not received any notice from the Assistant Commissioner to come and appear before him.
Let us see.
That is now my difficulty also.
No, just wait. That we'll ask the government to.
Yes, my lord.
So as of now, we'll ask the private respondent not to create any third party.
Please.
Now, do you want to contest in the remand only? We can ask the AC to dispose.
Yes.
Huh?
Insofar as affecting entries, we are agreed of.
Entire proceedings go. Entire proceedings go. Lord, may I request my lord to get these learned single judge records. What pain learned single judge has taken, that will be.
Just 1 minute. Now, what we could do, if, I don't know what your legal stand is, we could put them on terms, saying till the conclusion of the proceeding, they will not create third-party rights. If all contentions are kept open and you feel that you could go before the AC with all contentions open, that could be done. But if you want to contest in the writ appeal, then we will hear the writ appeal. As you say.
I would challenge the order of remand.
Remand.
I would be against the
Okay, let us-
state also,
let us-
because I have lost the land also and now paid
Let-
the compensation.
let us-
also. Let
I
them
may be
take a
granted
call.
time to
what
file
they want to
objection.
give up.
Let us,
I may be granted time to file objection, I'll file.
yes, yes.
Normally, there is a delay of 83 days.
We'll condone the delay,
Yes,
83 days.
delay may be condoned.
The IA. Two of 25 is allowed excepting cause shown, delay in filing the appeal is condoned. Full stop. After hearing the matter for some time, respondent 1 and 2
Yes.
are directed not to create any third-party rights pending further consideration. Relist the matter week after next. GA accepts notice for respondents
3 to 6, madam.
3 to 6.
6, yes, madam.
Necessary stand to be taken
Please.
as regards contention raised in the appeal by the state. Yes, next.
So far as remand is concerned, my lord, we'll proceed, my lord.
Order me. Clarify.
So far as remand is concerned, my lord, we may be permitted to proceed.
Writ appeal becomes infructuous.
The office objection regarding furnishing of
Translation.
copies of Kannada annexure is kept in abeyance for the present. Full stop. Insofar as the other office objection relating to furnishing of legible copy, counsel for the appellant undertakes that legible copies would be furnished of those documents as are relied upon at the time of hearing. Accordingly, said office objection is kept in abeyance in light of the undertaking. Full stop. It is clarified that pursuant to the order of the single judge, no further proceedings to be initiated upon remand as directed. Yes. Okay.
Number 22, punishment.
Hearing for the appellant, my lord. As per the office objection, my lord, is the as per the
Office-
annexure D and my lord the G.
Furnishing of translated copies of
Please,
annexure D and G is kept in abeyance for the
Already I
present.
filed, my lord, is the IA, my lord.
Huh?
I'm already filed